Yeah, we're ready whenever you are.
Okay. Here you go. Okay. Calling this public hearing to order at 7 p.m. on Wednesday, May 25th, 2022. This meeting is being taped for transcription purposes only, and the written minutes and attachments, if any, will serve as the official record of this meeting. Any board member who has a monetary interest or has a conflict, including ex parte communication, should disclose now. I will now ask the zoning secretary to call roll.
Glabro.
Here.
Hoop.
Here.
Zelesnik.
Here.
Schaefer.
Here.
Rubel.
Here.
Schrader.
Here.
In the audience is trustee Augustine, zoning inspector Wilson, and are there any trustees? Okay, that's it.
Ms. Augustine. The Medina County prosecutor or not?
I'm sorry, also the Medina County prosecutor.
Okay. Assistant.
Assistant.
All right, Brian. And the attendants, you want to pass it down. All right, at this point, would you read the legal, please?
The Hinckley Township Board of Zoning Appeals will hold a public hearing on Wednesday, May 25th, 2022 at 7:00 p.m. at the Administration Building located at 1410 Ridge Road, which is on the southwest corner of the intersection of State Routes 3 and 303, with a virtual option through Zoom. Subject of the hearing is as follows. An appeal from decision of Administrative Officer AP0265 was submitted by applicant 729 West 130th Street, LLC, and Brent Rooms, property owners of 729 West 130th Street, Hinckley, Ohio, permanent parcel number 01703A16018, to appeal from the decision of the zoning inspector ruling that the building and land no longer qualifies as a non-conforming use tavern/bar/nightclub. Inspection of this property will take place on Saturday, May 21, 2022 at 10:00 a.m. Zoning reference Chapter 8, Section 8.3, non-conforming use of buildings and land, subsection 8.3.d, discontinuance of use of the Hinckley Township zoning regulations. Copies of these applications and other supportive material will be available for public viewing from the date of this notice to the date of hearing at the zoning department located in the Administration Building at 1410 Ridge Road, Monday 10 a.m. to 6 p.m., Tuesday through Thursday 9 a.m. to 2 p.m., and Friday 9 a.m. to noon. Information may also be found on the Hinckley website at www.hinkleytwp.org under News and Events titled Board of Zoning Appeals _Public Hearing. All interested parties are asked to attend this hearing or to send written comments to the Hinckley Township Board of Zoning Appeals, P.O. Box 344, Hinckley, Ohio 44233, and must be present to give testimony. Log into www.hinkleytwp.org for Zoom option.
Thank you. All right, and have notices been sent to the appropriate property owners?
Yes.
Okay. The Hinckley Township Board of Zoning Appeals acts within the authority of Section 519 of the Ohio Revised Code and exercises its powers as provided under Chapter 7 and 13 of the Hinckley Township zoning regulations. All public hearings are open to the public. All persons wishing to testify must do so from the podium, must be sworn in, and evidence and testimony must be pertinent to the hearing. It is at my discretion to limit any personal comments, personal attacks, opinions, and repetitious statements or testimony or evidence previously given. Disruptive persons will lose the right to remain at this hearing. Personal attacks will not be tolerated. This is a hearing upon the application of 729 West 130th Street, LLC, and Brent Rooms, property owner of the property located at 729 West 130th Street, Hinckley, Ohio, to appeal the decision of the zoning inspector ruling that the building and land no longer qualifies as a non-conforming use as a tavern, bar, or nightclub. The applicant has submitted a packet that the board has in front of them. It includes the original application for the applicant submitted by the counsel for the appellee, and the copies of emails to the BZA, emails from applicant's counsel, email from the Medina County Assistant Prosecutor, and an email from the zoning inspector, and a site map with the owner information. That should all be in your packets. And all of these items are related to this appeal. Notice of application was properly given in local newspapers, and the application has been available for public review and comment. I will now ask the secretary if there has been any phone calls or any visits or correspondence received according to this, related to this application.
No letters or correspondence received, and there was a resident who visited the office, Peter Petilio.
Okay. I note for the record that non-written communication made by known or unknown persons not under oath at a properly noticed hearing is not accepted by the Board of Appeals as testimony. Each member of the Board of Appeals has been provided a copy of this application and a copy of each of the documents submitted in support of it. We will now poll the board to make sure that the packet was received and also a site visit was conducted.
Calabro,
Yes on the packet and yes on the site visit on Saturday, whatever that date is. Say Saturday, May 21st.
who?
Yes, and I did a site visit yesterday, so 5/24.
Okay, Zelesnik,
Yes, and site visit on Saturday, May 21st.
okay, Schaefer,
Packet, yes, and visit on the 22nd Sunday.
Rubel,
I have not received the packet other than what was provided to us via email, but I did complete a site visit today's date.
Okay. Provided via email in what way?
I received the notice of appeal via email,
Okay.
but the packet I have not had a chance to review.
Okay, that's fine. All right, written communications from persons not present this evening may include communications that are not made by affidavit. Because these communications are made by persons not under oath, they are not accepted by this board. I also note that written communications may include some writing by affidavit by persons that are not present this evening and therefore cannot be subjected to cross-examination. These affidavits therefore will not be given much weight, if any, in the decision of the board on this matter. This board does have the power to grant an applicant's request for an appeal from a decision of administrative officer. Those people that wish to speak must do so from the podium and must state their name and address before addressing the board. And all testimony must be given from the podium. So, for the benefit of the virtual audience, we ask that the audience save any personal conversations after the meeting because sometimes it's very hard to hear virtually. At this point, I would like to ask maybe the applicant to come up or the applicant's representative to come up to the podium.
Good evening.
Good evening. If I could swear you in.
Will Muniak, yes, go ahead.
Swear to tell the truth, the whole truth, and nothing but the truth as you shall answer unto that.
I do.
Thank you. All right. I'm assuming you are the one that submitted the appeal
Yes,
for the applicant?
yes, I did. And I understood there were two issues tonight. Well, one was the notice that was provided to the applicants. And the notice was given by Mr. Wilson in an email. And that email notice was sent to one of the property owners and not two of the property owners, or not both property owners. The email notice that Brent Rumis received via email didn't contain a whole lot about any specific findings, didn't say anything about any kind of appeal rights. And again, it was sent to one of the two property owners. So, you know, one of the first, I mean, it was very much unlike even the notice that they got for this hearing, or very much unlike the kind of notices that are set forth in the zoning code for other kinds of, you know, things, that notices that people get. They might get a certified letter, they might get a letter. This was an email. And so it being sent to only one of the property owners, if there's any issues with respect to the timing of the appeal, these are some of the things that you need to take into consideration with respect to, you know, very significant taking of the property without really much notification, and without notification to both of the property owners. And
I'm sorry, who's the other property owner? that you're
729 West 130th Street. And that's an LLC. It's an LLC.
Mhm.
And Brent Rumis, or Tom Sims, is a member of that. There's a statutory agent and lives right here in Hinckley. What's your address?
So Tom's,
I'm sorry.
No, go ahead. Sorry. Well, I'm sorry. You have to be at the podium to speak. So Brent Rooms and Tom Sims. So are you saying that Tom was not aware of this?
Tom did not receive any notice.
He did not receive any.
No,
Okay.
no.
Was he aware that prior to March 15th, was he aware that this was a question as far as what the decision that the inspector had made?
I don't know that he was aware of a decision that had been made.
Okay. Okay. So you're referring to the March 15th email
I am.
sent by our zoning inspector?
Yes.
And you're saying that wasn't complete, what it was about? Didn't explain?
Well, it didn't explain what their appeal rights are. And it just said, well, the property.
But we don't have it in our code that we need to do that.
Yeah, right. But it was an email and it just said, yeah, the property, there hasn't been a liquor permit there since January of 2019, which I think is actually technically incorrect because it was actually open till April of 2019.
Okay.
Right.
Are you aware how the zoning inspector became aware that it wasn't operating?
I have not spoken with Mr. Wilson, no.
Okay, we'll get him to come up. So you're, okay, so when would you say that notice was given? So March 15th, you're saying that's not when notice was given?
Well, there was an email notice sent. I didn't receive that myself until I wrote.
Right, but the applicant was, or the owner was
Yeah.
notified on March 15th.
Right, yeah, I don't think he knew March 15th because he didn't open his email. I mean, he didn't get it. I don't think he opened it that day.
So when do you think he knew?
I don't know when. It was, I mean, a few weeks after that, probably. It was before.
Well,
Go ahead.
there's documentation. Well, okay, March 15th is when he was sent the email. Prior to March 15th, there was a sequence of events that conversations were going on because there's phone log and I guess we'll get the zoning inspector to come up and testify to that maybe.
Yeah.
Instead of me telling you. But specifically on March 4th, there was a phone call from Mr. Rooms. Oh, actually, it says, and I can read it right off of here on March 4th. Brent Rooms and Thomas Sims stopped in to discuss the adult daycare and has an interested buyer, owner of Caddyshack, who is looking to purchase property and transfer liquor license and run as a restaurant bar at 729 West 130th. They would like to discuss with you and the trustees as to why they are not allowed to continue their business at that location. Specifically subsection 8.3D, discontinuance of use. And it states the code. Which thereafter, Brent Rooms tells me, Nick from Caddyshack, spoke with Nick. Nick is asking if there is any recourse for him to appear before the BZA. This was on March 4th. That
Okay.
Mr. Sims and
Could I get a
Mr.
copy of what you're
Rooms-
reading from?
Sure. It's the phone log.
Yeah.
Actually, it's a zoning activity log that I obtained from our records from our secretary, which she can testify to too. So, to your point that he didn't know on the 15th or after, I mean, I think he did. And we can maybe get him to,
Yeah, I mean, he can, I mean, I'm not saying he knew there was an issue.
okay.
He didn't know it had been decided, no, you were definitely not operating here. That's it. You're done.
Well, I think he was given notice by the zoning inspector to that effect, exactly. That it was no longer, it was, the non-conforming use ceased since it was not, after 2 years. And it was way beyond 2 years.
Which gets into another issue in the case, which, you know, the discontinuance has to be a voluntary discontinuance.
Right, but
Which-
I don't even want to talk about any
Okay.
of the details of that.
Okay.
We need to establish that. I mean, I think what we're trying to establish is that the notice was given on the 15th and then on the 6th, and well, okay, if I can get Tom maybe to come up.
Sure.
I'd like to ask him some
Sure.
questions. Tom, can I swear you in?
Yes, you may.
Swear to tell the truth, the whole truth, and nothing but the truth as you shall answer unto God.
I do.
All right. So, Tom,
Could you state your name? I'm sorry.
Tom Wilson, zoning inspector.
how did, you sent an email on March 15th. Can you give us some history how this came about to get this email sent and
Sure.
anything you can tell us?
Well, our zoning code, just for the record, this building sits in our R2 residential district. And it had been closed for a while. And so I went to the zoning resolution, and I thought perhaps in R2 we had some conditional uses, but under R2 residential, tavern is not a conditional use. And so then I went to page 89 of our code and talked about a non-conforming use. And a non-conforming building happens when something is established there and before the code is written, and then once the code is enforced, that business stays there as a non-conforming use. And then our code tells us that if a business isn't active for a period of 2 years, it loses its status as a non-conforming use. What I did was I called the Liquor License Bureau. Richard Carpenter is head of that down in Columbus, and I asked him if he would be able to look up and see if the liquor license was still active. And that's when he told me that it was it had not been active since January 11th of 2019. So I did some simple math, and the tavern had not been operating for over 2 years. And that's when I made my ruling that they had lost their
Okay,
status.
okay, that's, so can we skip to where on March 15th, you sent an email to
I did.
the owners or to Brent Rooms,
And
one
I
of the owners.
and I called him.
You sent an email on March 15th stating that they were no longer able to operate because it was a non-conforming use and they were not operating for over 2 years.
That's correct.
Okay, so you also called on the 15th?
Yes,
Okay. Because I see it here on the log that you sent an email and you called.
that's correct.
And you also sent an email to and I believe that at that point, he said he was obtaining an attorney.
He said he would, yes. And so I let our county prosecutor know that there could be a hearing. We didn't know at that point, but
Okay, and how did you let the county prosecutor
I
know?
sent Brian Richter an email.
Okay, and that was on the 15th also when you.
Probably was, yeah.
Okay, so did you get a response from the owners?
I did. They came into the
When did
office.
that happen?
I believe it was, well, they came into my office. I believe it was 15th or 16th. I'd have to look on my
The
log.
next day?
Next day, yes. And we talked about why I made this ruling. And
And who came in, Tom?
Mr. Sims and Mr. Rooms.
Okay. All right, so according to your testimony on the 16th, both Mr. Sims and Mr. Rooms both knew that you had sent them a decision. And prior to that, there was conversations, but were you told that, were they arguing that you didn't send any kind of notice? You didn't get anything? What prompted you to send the email on the 15th is what I'm trying to get.
Well, I just wanted to let them know that my
They were
ruling.
formally
Yeah,
noticed
right,
by your email on March 15th.
correct.
And on March 16th, the next day, they came in and wanted an explanation.
I understand the code a little bit, right.
Anybody else have any questions of Tom?
What about the conversation prior to the 15th you mentioned?
As far as, on the 4th, I was answering the question that their counsel was saying that the other owner was not notified, or he was not aware of this.
Okay, I thought there was a comment about conversation with someone else inquiring about the place. So, that's
Yes, on the 4th,
On
there
the
was,
4th, yeah.
yes, on the 4th, Mr. Sims and Mr. Rooms stopped in to discuss the adult daycare because they had an interested buyer.
Yeah, but that was not with Mr. Wilson.
I don't know who that was with, but it's noted on here.
I believe it was with me. I'm not sure. We had a lot of correspondence, but yes, there was an interested party, and that's why they were curious why the liquor license had been canceled. And I told them they'd have to go to the state of Ohio to find that out. I don't know.
Okay. So, okay. Then if I could get, and then, okay, so then can we move forward to, then we, apparently an appeal was filed, and it was filed on April 14th. So I think, anybody have any other questions of Tom?
No.
Okay. Suzanne, can you step up to the podium real quick?
Before you go, do you have any questions?
Well, I wanted to call him back up, but I wanted to get Suzanne real quick.
Suzanne Peterlin?
Swear to tell the truth, the whole truth, and nothing but the truth as she'll answer unto God.
I do.
Okay. So Suzanne, there was an appeal filed on behalf of the owners by their counsel, Mr. Muniak, and I believe it was filed according to what we have on the 14th. Did you receive that on the 14th?
Yes.
Okay. Whereas it also forwarded to the Board of Zoning Appeals as it states in the code that it should be.
Yes. Later the afternoon, it was forwarded to, on behalf of you and Zoning Inspector Wilson. The email that was received was forwarded to the Board of Zoning Appeals members that late afternoon.
Okay. That's all. I just wanted to establish that it was
Okay.
filed on the 14th. So
Okay.
thank you.
You're welcome.
So, Mr. Muniak. The reason these, I guess, and I'm sure you know, the reason these, we're going over these dates is because we, the board operates under the authority of Section 519. And Section 519.15 discusses appeals to the Board of Zoning Appeals may be taken by a person aggrieved or by any other officer of the township affected by any of the decision of the administrative officer, which would be Mr. Wilson. Such appeal shall be taken within 20 days at the decision by filing with the officer from whom the appeal is taken and with the Board of Zoning Appeals a notice of appeal specifying the grounds. So 20 days. So they were notified on the 15th, March 15th, at the latest March 16th, and then an appeal was filed on March 14th, 29 days later. I'm sorry.
April.
Oh, I'm sorry. Yes, April 14th. April 14th, it was filed.
I understand.
So we're beyond the 20 days. So I don't know that we can even go on with this.
Yeah, can I ask my clients to respond to the testimony by Mr. Wilson?
The timing?
Yeah.
Sure.
Yeah, so we get that clear on the record? Sure. Who wants to go first? Come on up. I mean, you heard Mr. Wilson explain the sequence of events as he understands it.
Could I swear you in?
Sure.
Please state your name.
Brent Rumis?
Swear to tell the truth, the whole truth, and nothing but the truth as you shall answer.
I do.
Mr. Rumis, you heard Mr. Wilson testify about the events, about the notice and the meetings that took place. Can you verify that? Is everything you said correct to your understanding?
No.
Okay, well, can you explain what's not correct?
Okay, we came in here, as they said, when we heard from a party that we were thinking about selling the whole property to, Nick from Caddyshack. he was checking into getting, making sure he can get a liquor license. That's the first, he called down here, I think he talked to Tom Wilson, and that's when he was told there might be a problem. So yeah, me and Tom came down here. All we talked to was like the lady that was working behind
That lady?
I think so.
Mhm.
You remember meeting us? Yeah, okay. So anyways, and she said that we'd have to talk to Mr. Wilson. So we called a couple times and eventually did talk to him over the phone, and he said what he said, that it had been over 2 years it expired, but we never met, and I've never met him in person, either as Tom.
Okay,
We never came down here and met.
right.
We never knew that there was like 21 days to appeal or anything like that. We never got any kind of notice.
It's not in our code that we need to give you the procedure or anything, but I mean, so you're testifying that you found out when? So if we start counting 20 days, but it doesn't matter when you found out. The appeal was, it matters when you found out. So when do you say you knew that you were no longer, it was a non-conforming use that could no longer be, your property could not be used that way anymore? When do you
I
say you
didn't find out until you told me an email had been sent, right? Yeah, because it had to be like, what day were you saying it was on?
According to what we have, you had asked Mr. Wilson, you said to Mr. Wilson that you didn't get any notice. How could we just,
Right.
abandon the place?
Yeah, we
So
didn't have,
that prompted Mr. Wilson to send you an email on March 15th. So if
okay,
you go from March 15th to when the appeal was filed, which was April 14th, it's beyond the 20 days.
yeah, but
More like 29 days.
I don't know when I received that email. I mean,
Well, if
Well-
you didn't reply to the email, which
No.
was sent on the 15th. However, according to our records and according to Mr. Wilson's testimony, you came in the next day, which would be the 16th, March
No.
16th. So if you were aware on March 16th,
that's
and
incorrect.
the appeal,
I've never met Mr. Wilson. We never came in the next day. I've never met you. Never.
Okay, well,
I mean, I'm not lying.
did he call you? Have you ever talked to him?
I talked to him over the phone that one time.
Did he call you? Did he call you and say, I sent you an email?
No,
you
I don't
asked-
think we
you
said
asked-
anything about an email.
Did you tell Mr. Wilson that you didn't receive any kind of notice?
Right, we told them we'd never gotten any kind of notice because we figured if there was a zoning change coming up, the property owners would have to be notified, and I would assume in writing, and we never got anything.
Well, the township doesn't know if you were in operation or not, because they don't check to see who's operating. The way that I believe Mr. Wilson or the township knew that you were not operating was through the state. They called to ask questions about about the property because someone was interested in getting a license for it, right?
Right, well,
Renewing it
there was a license being applied. There was a current application down there for a license. There was more than one.
You were not operating.
No.
There may have been an application.
No, we were waiting for the license.
There still is a license pending per application.
Right.
Permit planning.
It's against the law to operate without a license.
Can I ask Tom Sims a couple questions?
Yeah.
That's okay. Tom, sorry.
Yes, please.
Thomas Sims, 1200 River Road, Hinckley.
What was your name again? I'm sorry.
Thomas Sims, S-Y-M-S.
Swear to tell the truth, the whole truth. and
Absolutely.
nothing but the truth as you shall answer unto
Yeah.
God. Okay.
Tom, you're a member of an LLC. What's the name of the LLC?
729 West 130th.
And does the 729 West 130th have an interest in the property?
Yes, 50%.
729 130th Street, not to
Yeah.
confuse the name
Right.
of street.
Right.
So did you receive notice?
Never.
Well, let me finish
Go
the
on.
question. Did you receive any notice from Hinckley Township that the property no longer constituted a non-conforming use?
Nope.
Okay.
No.
Did you receive any phone calls about that?
Nope.
Your wife is a statutory agent for the company?
Yes.
Did she receive any notices?
Nope.
You live at the same place?
Yes.
What's your address?
1200 River Road.
Right here in Hinckley?
Yeah, right down the street.
That's the address for the statutory agent?
Yeah.
And you or your wife never received any notice
Never.
from Hinckley Township?
No.
Okay.
And they're supposed to be in writing too, not by email. It says right in your laws.
Well,
So nevertheless. we
yeah,
just wanna-
yeah. You heard Mr. Wilson testify earlier. Is there anything that you need to correct?
No, I've never had a conversation with Mr. Wilson myself. I never knew who he was. First time I've ever seen him.
Okay.
Yeah.
All right.
Can I ask you when you became
Sure.
aware of this?
I
I'm sure
became,
you haven't had a conversation with Mr. Wilson, but have you had a conversation with your partner?
yeah,
Okay, so when did he tell you that all this was coming?
I'm not sure of the date, but it was well after, he just got the email and he discussed it with me, I don't know, a couple weeks later. Yeah, and it's supposed to be in writing. It's not supposed to be an email.
It's not in our code that we.
Yes,
have
it
to
is. I
notify.
got it right here. It says if zoning violations are supposed to be in writing. I mean, it's your
It says
law,
it
it's
right
not
where?
mine. Right here. I'm looking at it right now. If I can get it to, it says, the township inspector shall, upon inspection and identification of a zoning violation, which I'm assuming this is, send a written order to the landlord or responsible party requiring him or her to remedy the violation. That's your,
Well, you're not in violation. You were,
Well,
you were not
okay,
operating.
well. then
You were
now we're
not
splitting
operating,
hairs.
so it
Okay.
wasn't a violation.
Oh, okay.
And
I do believe that emails are considered,
Well, then
legal
they should
documents now,
include
and
that in the
written
laws
order.
as, written or emails.
I think what we're trying to establish is when you got noticed. When, well.
I never got a notice. Brent got the notice.
What is the date?
Okay, go on.
Thank you.
So if I can just, let me just state for the record, I had written a letter. I had met with my clients. I had written a letter to the township,
On the
I think to Mr. Wilson on April 6th.
Mhm.
And obviously I didn't file an appeal yet because I didn't know that there was any decision that had been made. And I did not find out until April 12th when I received Brian Richter's letter to me enclosing a copy of this decision. I had not seen it before. And
Well, obviously it's between you and your client, but are you expecting us, are you telling us that your client just came to you without, you hadn't seen the notice, but they knew
No,
that they had been notified that they were no longer a non-conforming use? that
no,
they
I
were no
know
longer-
you're asking me when I became aware of it.
Yes.
And I became, even though I was, in communication with my client, I became aware of it through Brian Richter's letter on April 12th.
On April 12th.
That's the first time I got notice that there was a decision that had been made.
Well, your letter, your email.
Yep.
Is asking, if any written notices and/or applicable violations were issued, please forward the same to my attention at your earliest opportunity. And that was dated April 6th.
Yes.
And then I believe April 12th, Mr. Richter responded to your letter saying that they serve as legal counsel for Hinckley Township, and as legal counsel, this office has been asked to review your letter and respond on behalf of this board. And he specifically says Mr. Rooms was provided with the enclosed attached written ruling in the form of an email on March 15th, and I'm providing this to you. So that's all that really Mr. Richter did, was provide you what you had asked for, which was any written communication from the township, which there wasn't any, and it's not in our code to notify and say, hey, are you operating? You might, it's coming up in 18 months, you haven't been in business for 18 months. If after 24 months, you're you're done.
Well, I'm
I mean,
just saying
it's
that
not-
I had been in communication with my client, and if there was a communication that was so important that would have triggered appeal rights, I would have I thought they would have given it to me in my hands. Apparently, they didn't have that, or didn't think they had it, and one of them certainly didn't have it. So I filed a notice of appeal 2 days later because I didn't have anything written. I didn't have any decision.
I knew nothing about it in writing.
Well, all we can go, okay, anybody else on the board have anything to say about this? I mean, because all I can go on is based on the dates of when the notice was sent, when the appeal was filed, and if we go based on the code, and, based on the Ohio Revised Code, which is the authority that this board has, it's beyond the 20 days. Therefore, it's out of our jurisdiction to even hear this.
And that includes notification to both. One of the owners didn't get a notification.
Mr. Richter, would you like to contribute?
Do you mind if I clarify something?
Please.
Because I do have some questions for is it Mr. Sims?
Yeah.
You're one of the owners?
Yeah.
And Mr. Rumis is the other owner? Okay. And your wife's name is? Debbie
Sims.
Yeah. And you said she's the statutory agent?
Yeah.
And who's Adam Labadie?
He was the one of the original liquor license holders.
Okay. Are you aware that he's registered as a statutory agent?
No, there was a discrepancy on the there was two LLCs filed under 729 West 130th. That's a different 729 West 130th. He's
So
got
it's
nothing to
not
do with
729 West 130th DBA adult daycare?
No, this is 729 West 130th LLC.
Okay. All right. I just wanted to clarify it. And I'll move that up right now because I just wanted to make sure,
Sure.
because I'm wondering how the board would, or how even Tom would know, who the owners of the property was. So, all right.
Well, my thoughts are if it sounds like it may be confusion that who the second owner was, if we even knew there was a second owner. And if the one owner was notified, if I had a partner, I sure would talk to my partner right away to say, hey, we got a problem here. And the fact that it would come up 2 weeks later just doesn't make sense to me.
And we're talking almost a month from when their attorney, the notice was sent on March 15th, and 3 weeks later, April 6th, there's an email from Mr. Mariniak asking, nothing is mentioned about filing an appeal. It's just asking for any record, any notices or any documentation that was sent to the applicant. And it is not in our code to send anything to the applicant. And I believe that this came up, and there's been, and we don't need to get into everything that's gone on with the property as far as the 3 years or almost 3 years that it was not operating. There was several calls and several things that it was an indication that a bar was not happening, that there was nothing going on. Okay. But that doesn't matter. What matters is that you had asked Mr. Wilson to put something, you said prior to the 15th, you had told Mr. Wilson, well, we didn't get any kind of formal notice. So he put an email together on March 15th, giving you formal notice. And I can only speak for myself on this board, that it is very hard for me to believe, as Mr. Zalesnik just said, that if you are partners in something this serious, where you're being put out of business, according to what you said, that you wouldn't discuss it. You would discuss it 2 weeks later.
Well, after we, I don't think I got it right away. And then by the time,
well, okay.
A couple weeks later, when we found out for sure, and we made the appointment with him, like pretty much immediately after we found out, and then that took a while. We didn't even know there was a 21-day or whatever thing.
Well, I mean,
Can I,
this is all that we can go by, yes.
can I, front one's coming up. I'll share this with you too. I just wanted to get it on the record. Mr. Rumus, this is a printout from the Medina County Auditor site. What property is listed there?
729 West 130th.
And who are the property owners identified?
729 West 130th Street LLC and Brent Rummis.
Two different property owners.
Yes.
Okay. And the tax mailing address for 729 West 130th Street LLC, what is that?
729 West 130th.
No, that's the name of the company. What's the name of the address?
Oh, I'm sorry. 729 West 130th Street LLC, 1200 River Road, Hinckley, Ohio.
Right. Okay. And Tom, can you come up for a second? Tom, I just handed you something printed out from the Ohio Secretary of State. The business name identified as 729 West 130th Street LLC. Is that your entity?
Yes.
You're a member of that entity?
Yes.
It's active?
Yes.
Who's the agent?
My wife, Deborah Sims,
And what's her address?
1200 River Road, Hinckley.
Okay, thank you.
Sure.
I'm sorry, go ahead. I just want to get that on the record.
Chairperson Flagro.
Can I say something? Am I allowed to?
I'm sorry. I just wanted to explore the possibility of adjourning into an executive session very briefly with Mr. Richter for the purpose of obtaining legal advice concerning the notice issue.
I would rather not do that.
Well, it's up to you, but you wouldn't necessarily adjourn into an executive session because the board doesn't go into executive session. But you could certainly, adjourn the hearing for deliberation if you're ready.
Adjourn it to when?
Well, I mean, I think she's talking about maybe talking to me right now.
Right, right.
You can adjourn it and then come out and make your decision, or but you don't call it an executive session.
Right, right.
But you're a place a judicial board, and you could certainly deliberate that. But I would suggest taking all the evidence that you want to hear beforehand.
Right.
I just wanted to say that if you do adjourn for the purpose of deciding the timeliness of the appeal, I assume that that's different from the issue of the underlying merits as to whether or not
Yes, it is.
the use is discontinued. Okay, so I just wanted to make sure that if you do that, that we haven't waived those arguments. You don't want to hear them now because your issue's on the timeliness.
Exactly.
Okay, thank you.
Exactly.
And I would instruct in that way. I think they need to get at this issue first.
Yes.
Because they may not have jurisdiction to hear this case if it's a timeliness issue. But certainly if they did, you would be able to present whatever evidence.
Thank you.
Do I have a motion to adjourn?
So moved.
Is the board taking all the evidence in that they want to?
Tom, is,
Do we get anything from the audience or anything? Or not this
well,
point, we should.
I don't know as far
No,
as,
we
is there,
should not at this point.
yeah, I don't think there's anybody in the audience that has anything to do with the timeliness of receipt of this
You're right.
deal,
Sorry,
which is
yeah.
what we're discussing.
Yeah. Well, I would just ask, Will, do you have any questions of Tom since he testified? I mean, just so we get everything out of the way.
Yeah. Okay, I can ask. I guess I can ask. Well, go ahead.
I mean, Tom was, but whatever.
Is it okay if he says something else? It's you.
Sure, sure.
Yeah, I never knew about the email until about 2 weeks later after he got it, okay? I never got the email.
You may not have received the email, but did you have a conversation?
Well, we knew there was a problem, but that's.
So you were aware of the problem?
Well, we knew there was, I wasn't sure what it was exactly, but we knew there was a problem with the amount of time that it was. But, I mean, we come to the meeting, you send us registered letters. I mean, with the proper thing to do. I mean, you can say that you wonder why somebody wouldn't talk about it or discuss something so important. but we didn't. He didn't.
Okay, Mr. Rooms and Mr. Sims. Mr. Sims?
Guys, let her ask the question.
Okay, go on.
Mr. Sims, did you ever come into the township? You say you never saw the zoning inspector, Tom Wilson.
Never met him.
Have you ever been to the township?
Yeah, to
Have you
talk
ever
to
come
him,
in?
but he wasn't here.
Okay, he wasn't here. So you've been here.
Yeah,
Did you talk to maybe to Suzanne?
she said to talk to him.
Okay, and did you come in together with Mr. Rooms?
Yeah.
So do you think you came in on March 4th? Do you recall coming in on March 4th?
I don't know
and
what the
talking
date,
to-
I don't know what the date was.
Okay. Prior to this email, you were notified about this email 2
Mhm.
weeks later. Prior to that, do you remember coming in here? So that might have been March, if the email was sent in March, maybe the beginning of March? You don't remember if it was the 4th?
No.
But you and Mr. Brooms came in
Right,
to the township and spoke maybe to,
Right.
not Mr. Wilson, but maybe to the secretary,
right.
right?
Okay.
You remember that?
Yeah,
Do you remember what the conversation was?
just, we wanted to talk to Tom Wilson. She said he wasn't here, so we asked when he was going to be here. He said she's only here on Mondays and Tuesdays or
Okay.
something, and we never made it back up to talk to him.
Okay,
Okay,
thank you.
sure.
Just a couple quick follow-up questions for Mr. Wilson. I'm sorry, go ahead.
Oh, go on. No, go on.
Before you do that, Suzanne, can you step up, please? Okay, I had asked you to, give me whatever, documentation you had, and you sent me, in an email, a zoning activity log, right?
Yes,
Was this from you?
yes.
Okay. What exactly is this, the zoning activity log?
It's our internal phone log or activity that we track, either phone calls or just zoning related questions. With Tom being part-time, that's how we usually document some of the activity that occurs in the office.
Okay, so now who updates this log or who writes in it?
Tom Wilson, zoning inspector, myself, and our other office assistant.
Okay. There is, in this zoning log that I got from you, there was something dated on January 13th, which we don't need to talk about. It's regarding this same thing. There was also a note made on March 2nd. And then the one that I'm talking about is March 4th. It says here, March 4th, Brent Rooms, Thomas Sims, name of contact, phone numbers. And then if I could just read it and then you tell me if you wrote this.
Sure.
Or if it's from you, or maybe, I don't know if Tom wrote it, because you said that it's either you or Tom that write in this log, right?
Mhm.
So it says here, stopped in to discuss the adult daycare and has an interested buyer, owner of Caddyshack, who was looking to purchase property and transfer liquor license and run as restaurant bar at 729 West 130th Street address. They would like to discuss with you and the trustees as to why they are not allowed to continue their business at that location. I'm assuming, did you write this?
Yes, I did.
Okay. I'm assuming when you say they would like to discuss with you and the trustees, you being Mr. Wilson.
Correct.
Okay. So you logged this in, they came in, and this is what their purpose was.
Correct.
And that's, at that point, you told them when Tom is here and when the trustees would be available or contact or whatever.
Yes,
So, and that's what this is.
correct.
Thank you.
You're welcome.
Okay, Mr. Muniak,
Yes,
you wanted to,
thank you very much. I just had a couple quick follow-up questions for Mr. Wilson, if that's okay.
Sure.
Did you, there was some discrepancy about meeting with these folks. Did you meet with them the following day?
Well, I met with, I know I met with Mr. Rooms. I'm not sure about Mr. Sims, but I think it was the next day, yes.
Okay, but you don't know if Mr. Sims was there?
I don't remember, I'm sorry.
The email that you sent to Brent Rumis on March 15th, 2022, is that the only notice that you sent?
Yes, and I followed up with a phone call to let him know that I'd sent him an email.
Okay. And did you contact Mr. Sims?
No,
Okay. Did you know that the property was owned by two?
no,
Who did you think it was owned by?
Mr. Rooms.
Okay. How do you know who the property, how would you know who it's owned by? I mean, do you have records that indicate it's owned by two people?
Well, as you did, I could go to county recorder or to the auditor's office and see that, yes.
Like, you don't have any records in Hinckley as to who the property owners are?
No.
Okay. Okay. That's all. Thank you. Appreciate that.
Just to clarify, so we get it for the record, Tom. Just to clarify, so we get it for the record, if you could stand back up. So you saying that you sent the email on the 15th,
Correct.
and then you're saying Mr. Rumas came in on the next day?
I believe it was the next day, yeah.
Okay, so that would be the 16th.
Yeah.
And then you had indicated that you made a phone call, but you didn't really say when that phone call was.
Well, I made a phone call when I sent the email to let him know that there was a email coming his way.
Okay. Did you talk to Mr. Rumas, or did you?
Yes.
Okay. You personally talked to him on the
Yes.
phone? Okay, I just want to make sure.
Okay, Tom, don't sit.
Okay.
All right, back to my, the log, the zoning activity log. On March 15th, 2022, I just want to make sure that this was you who wrote this in here. March 15, 2022, sent email explaining the reason for the non-conforming tavern was no longer permitted in R2 district. Also phoned Mr. Rooms and told him I would be more than willing to set an appointment to go over the code. He informed me he had retained an attorney who may call me. Is that from you?
Yes. It is.
Okay. You sent an email on March 15th at 1:06 PM to Mr. Rooms. Okay?
Correct.
You also sent an email on March 15th at 1:12 PM to Brian Richter, and it says, Brian, I wanted to make you aware the owner of the tavern, Mr. Rooms, has engaged an attorney to try and overturn my ruling. I will keep you posted, Tom. So these two emails coincide with your notes in the zoning log that you sent the email on the 15th. You also called him, say, I sent you an email, Mr. Rooms.
Correct.
And then you also followed up with an email to Mr. Richter
Correct.
on the 15th saying, I just spoke with them. They said they're going to retain an attorney
Correct.
and they may contact you.
That's
So
right.
that is from you, right?
Yes.
Okay, thank you. Is there anybody else that needs anything else before we adjourn? So do I have a motion to adjourn?
So moved.
A second?
Second.
Dave? All right, so we are adjourned at what? 7:52? Everybody ready? All right, so we're coming back from deliberation with our council at 8:11 PM. All right,
Just want to note, so you know, for the record, I was in there to answer your legal questions.
yes. For the record. You got that? Thank you. All right, so I believe, based on the testimony that has been given and what we have, I think that, and we operate under Section 519 of the ORC, and just based on that, the appeal shall be taken within 20 days. I believe I would like to make a motion to, at this point, to dismiss this hearing for an appeal of the decision of the zoning inspector, because it was not filed on a timely basis, and the decision of the zoning inspector ruling that the building and land no longer qualifies as a non-conforming use as a tavern, bar, nightclub. Appeal based on the Ohio Revised Code Section 519.15, which states that such appeal shall be taken within 20 days after the decision. This board does not have the jurisdiction to hear this appeal and make a decision on it. Therefore, I move to dismiss it at this time, this hearing. So
Second.
do I have a second?
Second.
All right, so we shall take a vote on that.
Calabro,
Yes.
Holt,
Yes.
Gillespie,
Yes.
Schaefer,
Yes.
Rubel,
Yes.
All right, so that is 5-0. The motion has been passed that we are dismissing this hearing at this point. The applicant, I'm sorry?
Dismissing the appeal, right?
I'm sorry, yes, dismissing the hearing, which was for the appeal of the decision by the zoning inspector. Any person that's adversely affected by this decision of the Board of Zoning Appeals may appeal to the Court of Common Pleas of Medina County on the grounds that such decision was unreasonable or unlawful. And at this point, do I have a motion to adjourn?
So moved. Or second. I think Dave got the,
Dave, in
yeah,
a second?
and I got the second.
So we are adjourned at 8:13 PM.